like to thank you all today for joining this webinar on IP evaluation. I hope you'll find it interesting and stimulating. This is one of the meetings we're having in preparation of the 6th Intellectual Property and Competition Forum, which will be held from June 23 to June 25 online, where we'll address standard essential patents in France and the future of it. And we very much hope you will be joining our conference. It is free of charge to join because Oxfirst is celebrating its 10th birthday around that time. And we thought we should make everyone who's interested in the work do a birthday gift. At the conference, we'll be talking about standard essential patents from an anti-suit injunction perspective. We'll look at component level licensing, and we'll also discuss issues around global patent enforcement and arbitration, among lots of other questions to be addressed. Yeah, if you're interested, you find that on our website. Just Google Oxfirst, the 6th IP and Competition Forum, June 23 to June 25, from 1 to 6 o'clock UK time in the afternoon. I've also asked a couple of ballet friends to perform, and I hope you'll enjoy the show. For our event here today, I'm extremely pleased to welcome such prominent contributors, speakers, and discussants. Sir Richard, Lord Justice Arnold, of the Court of Appeal of England and Wales, and Mr. Zeeger Vink, who is the trademark manager for a series of very well-known brands, which I personally like an awful lot, such as the Couples, which has wonderful fashion for women, but also Lacoste, which is perhaps more popular among men, and a couple of other very, very well-known trademarks. And the reason why I invited Richard and Zeeger to this conference or this webinar here today was because I thought we need to have a debate on the value of intellectual property and how to come to grips with IP evaluation. I kind of have the impression that this is a topic which often goes unnoticed and where we do not have enough attention to it, and where people honestly are still stuck in the question, can you actually do this? And we wanted to shed some light on that question and to address why IP evaluation matters, how IP evaluation can be addressed, and then perhaps also limitations and shortcomings. Yeah, with that being said, maybe I leave it to our chair to run the event further. We very much hope that we'll have lively discussions. So if you have questions, please ask them. We don't want to bore you with lengthy presentations. We hope this can be very interactive. And I'm particularly happy that Richard could make it after quite a trouble yesterday coming back to the UK. Simple things. Yeah. So we were hoping that we could have a perspective from a judicial perspective on the role or emerging role that intellectual property evaluation is taking in the courtroom, and if and to what extent the availability of an adequate assessment of damages or licensing rates can be an advantage of some courts towards other courts who are not doing that or disadvantage. And we also see Zeeger has just published a book on IP management, and I hope he can offer a corporate perspective on the role of IP evaluation. And I wanted to basically give my views more from a big eagle's point of view by saying really trying to sketch out the bigger picture here behind it, why I think IP evaluation and the further usage of IP evaluation is really an important step towards systematically using intellectual property as a tool for economic prosperity. With that being said, I think I pass the floor on to Richard.
Thank you very much, Roya, for that kind introduction. So, as Roya has mentioned, she asked me to begin by discussing IP valuation in litigation. And in trying to answer that question, I have to say straight away, one of the thoughts that occurred to me once I'd realized what answer I was going to give is it throws up a question which I hope we can discuss a little bit later, which is what exactly do we mean when we speak of IP valuation? Of course, in one sense, it's obvious, it's valuing intellectual property. But what does valuing intellectual property actually mean, and what does it actually involve? And the reason why I asked the question will, I hope, become clearer as I move along. So as a former advocate and now judge of some experience in intellectual property, it seems to me that one speaks of IP valuation in the court context, three possibilities immediately spring to mind, two of which are closely related to each other and which Roya has already touched on. And then there's a third one, which is a little bit different, as I shall explain. So the two that are closely related to each other and which Roya mentioned are damages and licensing. Now, let's start with damages. So the scenario here is that we have an intellectual property right and it's been infringed by someone. And so if there's been any challenge to validity, that's been resolved in favor of the right holder. Any dispute about infringement has likewise been resolved in favor of the right holder, and the right holder claims damages for the infringement. Now, certainly under English law, the way in which we assess damages is one of three methods. The first two of which are essentially factual inquiries. So the first possibility is if the right holder manufactures goods which are protected by the intellectual property right or provides services and claims that it has lost profits as a result of the infringement. And then you have a factual inquiry as to what are the right holder's profits and what's been lost as a result of the infringement. A second possibility is if the right holder is engaged in licensing its intellectual property in some way, and it claims that it has suffered a loss of licensing income. Again, it's essentially a factual inquiry. What licensing income has been lost as a result of the infringement? But the third method is where we get into something that might be considered to be IP valuation. If the right holder cannot prove lost profits or lost licensing income, then typically in most scenarios, the right holder will be able to claim a reasonable royalty, whether assessed on a lump sum basis or a running basis, for the use of the intellectual property for the period of the infringement. Now, this is typically a historical inquiry. We're looking at what happened in the past. And we're saying, well, what is a reasonable fee that ought to have been paid by the infringer for the use of the intellectual property in question, which they failed to pay because they infringed rather than obtaining a license? And is essentially a question of what is would have been agreed between a willing licensor and a willing licensee. So it resembles the second type of factual inquiry I've described, but it differs because, of course, you've got no actual license in these circumstances that's been lost. So it's a hypothetical license, and we say, well, what would be a reasonable royalty rate to be payable under that hypothetical past license, which in fact didn't exist. Now, what we're really doing in these circumstances is valuing the opportunity, because the infringer should have obtained a license, it didn't, and so we're valuing the opportunity that the right holder has lost to extract license income. But of course, the value of the lost license income must in some way reflect the value of the underlying intellectual property right that's been infringed. So in that sense, we are valuing the intellectual property, although I would say it's an indirect valuation rather than a direct valuation. So that's the most common scenario in which we come across something that might be called IP valuation in court proceedings. The second one, which Roya referred to, is the licensing scenario. And I would distinguish that from the first scenario in this way. a common example of this currently is with standard essential patents, which are subject to a FRAND obligation. That's to say that the right holder must license the patents on fair, reasonable, and non-discriminatory terms. And typically you have a dispute between holders of SEPs and implementers as to the value of the portfolio held by the SEP holder. And this is different from the first scenario, because whereas the first scenario is a historical inquiry, in this sort of situation, we're looking forwards to the expiry of the rights in question. And we're saying what going forwards is going to be a FRAND license rate for this portfolio of patents. And that's true whether one assesses it on a purely national basis or on a global basis. And here one is, I think, getting rather closer to valuation of the intellectual property rights in question, because of course, on a forward-looking licensing basis, although again, we're valuing the opportunity, it's because one is looking at it going forwards for the future, the question of the value of the portfolio becomes, I think, a little more central than under the purely historical inquiry that one engages in for a damages inquiry. Nevertheless, they're conceptually clearly very closely related. And we've had these kind of inquiries in other scenarios in the past. One that will be familiar to English patent lawyers that we had about 20 years ago, a lot of, was when terms of patents were extended from 16 years to 20 years, and the last 4 years, which were in essence free for the patentee, because when they originally obtained the patents, they didn't expect to have them, were subject to licenses of right. And then there was a lot of litigation about, well, what was the value of the license of right? Because clearly there were different views as to what these patents were worth in a license of right scenario on an extension of term. But it was a similar kind of inquiry conceptually to what we have in these FRAND disputes. And going back even before that, one had extensions of term for war loss and things like that. So these are in principle not new kinds of debates that we're having here. It's just a different context. So those are the first two scenarios I would identify. The damages inquiry is the first one. The second one is where we're looking at a forward-looking license. The third one that I would identify, which is really a bit different again, and I think approaches more directly the question of IP valuation, is where we have something from the mergers and acquisitions context. So a business is being sold, for example, and suppose there's some kind of dispute arising out of the sale of the business, and that gives rise to a dispute as to the value of the business that has been sold or there's been an agreement to sell. Now, of course, as we all know, whereas in the past, the assets of businesses were typically mainly tangible and only to a much lesser extent intangible. Nowadays, businesses that are being bought and sold, frequently their assets are mainly intangible rather than tangible. And in particular, we are looking at the value of the intellectual property rights that the business has. So if you're buying or selling that business, if you're trying to value what it is you're buying or selling, that clearly involves directly trying to value the intellectual property rights that are exploited and owned by that business. And then one really does come to the direct question of, well, what is the value of those intellectual property rights? So those, I would suggest, are the three main contexts that we come across in litigation. But as I think I have revealed already, they give rise to subtly different questions as to what we mean when we speak of IP valuation. Okay, I'll stop there.
Thank you very much. I don't think we could have gotten any better introduction into the topic. And I'm extremely impressed you could act as an IP valuation expert just as well, quite frankly, if you ever think of changing roles. Zeeger is coming more from the trademark perspective. And when I was discussing with him, I said, well, there's a cascade in terms of awareness on intellectual property valuation and management, where I'd say on top of the food chain, you will have the patents and the standard essential patents. Then there's a long break, then come the trademarks, copyright, design rights. And some of the barristers sent me case law on trademark valuation in English courts, and I found it was all a bit dated. I didn't see any brand new insights on trademarks. And Zeeger has started to embark on that question. He's, I think, one of the board members of INTA, the International Trademark Association, and INTA has embarked on a quite ambitious project to change that. And to understand better what can be done to recognize intellectual property, especially obviously being into trademarks, on the balance sheet, because the challenge we're having with intellectual property valuations is that these are off-book valuations. Intellectual property is often not recorded on companies' banks accounts unless it is associated with a direct financial transaction. So if you have a licensing transaction, you can look up what your accountant has done for your company. But if your intellectual property is held internally, such as the Lacoste brand or the Coca-Cola brand, it may not show up. It may show up as being of zero value. And this creates challenges from a judicial perspective, to be just and to be fair and to make a judgment which has that aspiration of saying, I did my best to respect justice. On the other hand side, for financial, for investors, for the financial community, it becomes very esoteric. If you think, look, I have these assets, they're really the key thing in my company, but you can't see them. That is a bit of a challenging sale. And if you look how investors are reacting to litigation and to intellectual property, there's basically nothing. And then someone starts a litigation, whoop, investors react, but not really sure how to react and to what to react. They're just seeing that something is happening, which they can't get a grasp on, because when they ask the accountants, they basically see zero value. And at the other hand side, this is also getting interesting from a tax perspective. Decades ago, when I was still in WIPO, I was sent over to New York to liaise with UN headquarters and the statistics office there and the Securities Exchange Commission in the United States, who said, there's something wrong here. We see the book value of a company being one story, and then the sales value being a completely different story by a factor of 100 or even 1,000. And we get suspicious if anyone is cheating on taxes or if we are missing out on something. And then they say, well, it's really a lot of that value comes from the trademarks or the patents. And it's an inconsistency which we are still having to come to grips with. And I think this is what Zeeger's project, which I'm trying to contribute, is very much about. But Zeeger, what are you, and you also have authored a book on the topic, so what do you say?
It's a very interesting topic, and the financial consequences can be huge. Maybe I should start with explaining why the perspective from a company may be a little bit different. And the question you have to ask again is, why do you do an IP valuation? And the previous speaker has already explained that there are, in a litigation scenario, several reasons to do that. I would say there are a couple of reasons more in a company perspective, in a commercial perspective. One of them, you mentioned it briefly, Roya, is also a tax perspective. If there are transactions within a company, for example, between a holding company and a subsidiary, there is the concept of transfer pricing, which means that you have to give a fair value to a certain transaction to make sure that it's compliant with the fiscal rules. And so that requires also an evaluation, or that may require evaluation of the asset in question, being the intellectual property right. That is significant in terms of value. So that is in practice a very much practice domain of IP valuation. And I would say increasingly more. There's another reason why we are concerned by IP valuation in a company perspective, and that comes to financial reporting. You mentioned it already. That can be external reporting, when companies have to publish their data because they are, for example, listed on a stock exchange, and so they are subjected to these obligations. But it can also be internal reporting, because normally a company management would like to manage assets, manage the organization of the company, and of course they need to have a full picture on the assets in the company, how much they cost, what their value is, to make the right decisions. That brings us to the accounting aspect that you mentioned, Roya, because who is going to make that calculation? What is are there any rules on that? Where there are rules, and there are international accounting standards. And when you look at them, it's quite interesting. And so we're talking about IP as an asset. IP is an intangible asset, as Richard already mentioned, and they are increasing in importance. We all know it. Companies, they own less and less physical assets, factories. Many things are rented or are subcontracted, and so the real value of a lot of companies is in their intangible assets. When you look at the international accounting standards, they do recognize IP as an asset. So it's not that it's excluded or that there's a formal barrier to do so. And there are also various ways of methods that are identified on how to value IP. The interesting thing, and that's what you mentioned, Roya, is that brands are excluded from being identified as an asset or given a value to it if they are developed internally, meaning that if a company develops its own brand, which is the typical situation, you file a trademark, you start investing in it, and it becomes a brand is a bit of a larger concept than trademarks. I won't go into the detail today because that's a whole different story. But they are, as long as they are internally developed, they cannot be recognized as an asset. There cannot be a value attached to it from an accounting perspective on the balance sheet of a company. You mentioned it is different when a company is acquired or when there is some sort of transaction involving that IP, because then it is considered that there's let's say an objective standard that has been applied by someone in a commercial environment. So then there's perhaps more security on the to what extent it's a reasonable valuation. But the exclusion of brands is a reality, and that has huge consequences. And I think they are not always taken into account currently. And we see that, for example, if we look at the annual brand valuation rankings that come out on a yearly basis, we see them, they're big press events in the meantime, and you see that all these billions or tens of billions of dollars or euros or whatever, the origin of the valuation report, but they are given to those brands because they have such a big consumer recognition, or they have so much revenue that they generate. But when you look at the accounting value of the IP of those companies, of those brands, and so that is public information generally that you can find for example, through the Securities and Exchange Commission, for example, where you have these mandatory filings in the United States. When you look at the balance sheet of those companies, you have difficulty identifying that value because basically it's not there, or only a fraction of what we consider the true commercial value. I can give some examples, recent ones. We saw the American Airlines that got a loan to get through the difficult COVID period, where there was, of course, a collapse of of international or national travel as well. And so they got an IP asset-backed loan. So they gave basically their brands and their AA.com domain name, and that's the domain name through which all the online transactions take place. And the asset value that was given to the IP, and that was also confirmed publicly in the financial press, was that the asset value was more than $10 billion US, and we're talking about the brands here and the domain name, so basically the branding aspect. But when you look at the balance sheet, the most recent one of American Airlines, well, you have difficulty finding a little bit more than 2 billion. So where's the difference? What happens if the CFO of a company confirms that the true value of the IP is 10 billion? It's not an exact number, but approximately. And the documents that are signed off by this same person that have to put a number on the assets they were talking about, they state 2. Second example is MGM, the film studio, and they have all kinds of media assets as well. They have recently been acquired by Amazon. You can see the reason of the transaction with all the streaming, the Amazon Prime product that they want to push. If you look at the value of that transaction, it was also reported in the international financial press as 8.5 billion US dollars. And again, if you look at the balance sheet of MGM, it's public information. It has been checked. It has been gone through extensive accountants validation. And again, we see maybe 2 billion in IP assets. So there is this huge discrepancy. And you can ask yourself the question, is that something we agree with this situation? Is it justified? Or is this something we should study more closely? My opinion is that we should study this more closely, and well, that requires some attention and discussion. I think this the consequence of this discrepancy means that when something doesn't have a big value on a balance sheet, it will necessarily trigger less management attention. Maybe not in the big transactions that I just mentioned, but the vast majority of companies, they will have the same problem. They will have a relatively low IP valuation or almost zero. And so when management, first of all, they are probably not IP experts, so they don't know a lot about these strange things like intellectual property and intangible assets. What's the difference anyway? So if you want to get management attention for this kind of asset and for these kind of rights, well, you have to make it visible first, and that goes through numbers in general when you look at the company management level. So this is a problem. The problem is also that this creates a disconnect between the financial and the legal side, because if there is not a good way to value IP, or if it's excluded anyway, no one's going to analyze it in detail. What are those assets? Are they well protected? Are they exclusive? Are they valid? These kind of questions with a legal nature, they will fall off the screen of senior management. So that brings me to a next element that I think is important here, and that is awareness for intellectual property and awareness for IP valuations. Roya, you mentioned it, that we need a bigger discussion, not just between us, but maybe a bit broader in society. Yeah, I think there are a lot of things to say about that. IP awareness is an element of IP management. It's about company management, and so it's you need to train internally. You need to create the attention, the necessary attention of the necessary people for intellectual property. That goes through trainings, but I think yeah, we have to make an effort together, as I suppose also a lot of people that are listening to us today. What can we do together to make this a topic higher on the priority list? And so I would love to discuss that further down. When you look at internally in a company and externally, it's about awareness, creating the right links, and putting the attention at the right place. I have been fortunate to discuss this with a lot of people. As you mentioned, Roya, this year I published a little book about it, company IP management, and one of the, I would say, lessons or recommendations is that everything starts with internal IP reporting. When you don't explain what you have, if you don't identify, maybe just already from a legal perspective, what are the IP assets that we have, it's a good starting point to start such a discussion internally. That's from a company perspective. When you look more at the societal perspective, maybe what we need is more harmonization on this level, on this topic, and I think there's a lot of work to do for all the people involved. It's interesting to know that there are tools available that try to harmonize IP valuation, and I would especially like to mention the ISO standard number 10668, which is exactly on this topic of IP valuation, and so it gives a certain number of tools or methods to do such an IP valuation. But what is interesting, if you look at it closely, you see that there are hardly any legal aspects to it, or IP in the legal sense about the let's say geographic coverage of those rights, or the strength of those rights, because that determines a lot what the value of a trademark of a brand is. And if you don't include that in a standard, you will right from the start have this disconnect again between the financial analysis and the legal analysis. And so this is exactly one of the topics that we're studying with a lot of interest at the INTA, the International Trademark Association. It's a project where we are reaching out to a lot of people, because this is it's quite a bit of a wide space on the map, because yes, very often it's lost in translation between finance and legal, and I think there are important connections to be made. I wanted to leave it at that.
Great. Could I just chip in there with a couple of thoughts? The first relates to this question that both Roya and Zeeger have touched on, of the way financial reporting standards treat the valuation of goodwill. And as Zeeger has eloquently explained, the basic principle is that internally generated assets, and in particular goodwill that is generated by a company, is not ascribed any value on the balance sheet. Whereas if there's a transaction involving that goodwill, at that point it will be ascribed to value. And as Zeeger has explained, when you look at the rationale for that principle, the rationale that's typically advanced by the accountants is the problem of having an objective valuation of internally generated goodwill if you don't have any market test of that valuation by way of a sale or a license or anything like that. Now, if you probe that explanation a little further, it's very clear that what lies behind it is a concern for the financial statements to give what the accountants call a true and fair value of the company. And why are they concerned about that? Our answer: for investor protection. The key audience for financial statements of companies are investors in that company. They're not the only audience, but they're the first and foremost audience. And so we have had a long-standing concern that investors are not misled as to the value of the company. And in particular, they're not led to think that the value of the company is more than it actually is. And therefore, there is a big concern on the part of accountants that if the management of the company are free to put on the balance sheet their own valuation of internally generated goodwill that has no kind of external market benchmark, then that could lead to balance sheets being inflated and therefore investors being misled. And when you look at it from that perspective, that's a very understandable concern and a very legitimate concern. But I think the question we have to ask is the one that Zeeger posed, which is, well, okay, but is there perhaps a negative consequence if we don't put goodwill on the balance sheet, even if it's purely internally generated? And as Zeeger suggests, there may in fact be negative consequences, and that therefore the concerns are really not all one way, which seems to have been the historic attitude. And maybe that's something we need to look at again. So that's point number one, but that then leads on to point number two, which is that, as Zeeger has said, there's a bit of a disconnect between what one might call the accountancy approach and the legal approach. And quite a good way of getting at that is the point that Roya mentioned earlier, which is if we look for case law on IP valuation, where do we find it? Answer, we find it mainly in the field of patents, to a lesser extent in the field of copyright and designs, and least of all in the field of trademarks. Now, why is it that there's so little case law on valuation of trademarks? Well, if you ask lawyers the answer to that, the answer that they will typically give you is that if you are a trademark owner and you have succeeded in showing that it's been infringed by some other party, the remedy you want most of all is the remedy of an injunction. You want an order of the court to get the other party to stop. And if you've got your injunction, you're much less concerned about any damages or profits there might be for past infringements. Now, that's not to say that it's no concern whatsoever, but typically what happens in trademark litigation is that once there's an injunction, then everything else gets settled. And typically will be a global financial settlement that will take into account damages and the costs of the litigation. And typically the trademark owner, provided he gets all his costs back, he'll be much less interested in pursuing any big claim for damages or profits. But then the question I would ask that follows on from that is, well, does that maybe tell us something about valuation, and in particular, the point that Zeeger mentioned earlier about the distinction between trademarks and brands? Is there maybe something here that tells us that actually that difference is an important one, and an important one from the valuation perspective? If as a trademark owner, all you want really, when push comes to shove, is an injunction to stop anybody else infringing your trademark, maybe the trademark as such is not worth that much really in terms of its value, but your brand encompasses rather more than just your trademark. Yes, it's the trademark and it's the goodwill associated with your trademark, but it's all the other things that contribute to the perception of your business in the consumer's mind. And maybe it's those other elements of value which are more important when it comes to this question of recognizing the value of brands in balance sheets. I don't know, that's speculation on my part, but I throw that thought out for consideration.
I would like to thank you both for the statements you have made. If I hear you, I just wish there were more people who had this type of perspective, because when I go out in the real world, I'm already lucky if people say, oh, you're an IP lawyer, Roya. If I try to explain, it's actually more complicated. I do the economics of IP law. I kind of like lose my audience. And then they have to explain, I don't mean internet protocol with that. I actually mean intellectual property. And that at latest at that stage, I kind of like tend to lose my audience. And what I hope, where we need to go further here is to really get more wide-scale awareness on the challenges we are facing with the type of gaps that we are currently having in accounting systems, and with the type of gaps we are still seeing in terms of understanding and awareness on why to value intellectual property. If we could somehow reach a bigger audience, then a bunch of people who know, a bunch of insiders who are perfectly aware of where things are heading, it is my firm belief we could strongly improve growth and social prosperity and welfare for humanity. I strongly believe that intellectual property as the legal dress to creativity and innovation is absolutely core and crucial for growth, and is absolutely crucial also to make humanity better off. We have a lot of research that shows that innovation is core to further prosperity and growth. This is nothing new, really. And if you look historically, agricultural societies, their GDP rates were fairly constant over centuries, because people used to do the same things over and over again, and society was kind of like stable and organized in classes. And that was it. And then came the Industrial Revolution, and came inventions on machinery, God knows what, and the game changed. And we had again a big game changer with the establishment of the internet. Massive game changer. The way we do business has completely changed. The intellectual property and the role of it, how to refine it in that new era, is yet a whole different story to understand properly. But IP valuation is an important puzzle in coming to grips with fully unleashing the power and the potential that the internet revolution has enabled. We have seen businesses that we couldn't imagine before, business models where we thought, really, this is possible? And we have it. And we're still dealing with an intellectual property legal system strongly anchored in the 19th century, if at all, even more backward. And then you go into the accounting systems, and I think they're still stuck somewhere in, I don't know, Renaissance times Italy, you know, which was a big thing at the time to have double side bookkeeping, which was a big Renaissance invention. But I think where we see a problem is that accounting risks to be extremely precise, but absolutely irrelevant. If you look at the accounts of Oxfirst, we have inventorized every desk, every chair, every computer we have, and we keep amortizing it over every year. And I think it moves from 10,000 to 6,000, God knows what pounds. But this is completely not what drives the company. It's the smart people, God willing smart people, or the not so smart people, the new perspectives. And if we're not coming to grips with it, we're completely gonna lose out.